And the transcripts were released to the public, but the transcripts are redacted in part. And all of the redactions have to do with the treatment that the prisoners suffered in CIA custody. And you can tell that because if you look at the transcripts, which are, again, on our website, if you look at the transcripts, you will have questions in which the tribunal will ask a question, for example, where did you grow up? And then there'll be the answer from the detainee. And then you'll get to the questions about the allegations against the detainee. And they'll say, you're alleged to have done this. Did you do it? And the detainee will answer no. And they'll say, the tribunal will say, but in CIA custody, you said that you had done it. Did you give that answer as a result of torture? And then there'll be a long blacked out passage in the transcript. And you know, this is odd on many levels, but it's particularly so because all of this information is actually already public. This is information that has been made public in the OIG report, and it's information that was made public by Mark when he got the Red Cross report and published the Red Cross report. All of this information is already in the public domain. But it gives you a sense of the lengths that the Obama administration is now going to placate the CIA. And I think the dean gave us a sense of one reason why they may be going to those lengths. So that's transparency. I'm not keeping track of time. Just somebody
I'm doing
okay.
fine.
The civil suits. So it may be news to some of you that still today, no survivor of the Bush administration's torture program has actually had his day in court. That is not for lack of trying. There have been many, many lawsuits brought, some of them by the ACLU, some of them by the Center for Constitutional Rights, some of them by private attorneys, dozens of lawsuits brought on behalf of people who allege that they were tortured either in CIA custody or in Defense Department custody. None of those cases have gone to factual hearings. And why is that? It's because the Obama administration, in each of these cases, has invoked one or another threshold doctrine in order to get the case thrown out before a factual hearing. In some cases, the Obama administration has invoked the state secrets privilege, arguing that to litigate the case would require the disclosure of state secrets, and accordingly the state has to be dismissed at the outset. The Obama administration has had a number of cases dismissed on that ground. In other cases, the administration has argued immunity doctrines. It's argued that, well, even if it's true that these prisoners were tortured, it was not established at the time they were tortured that torture was unconstitutional at Guantanamo or that they had constitutional rights to assert. And so cases have been thrown out on that ground. There are other cases, including the Arar case that Mark referred to earlier, the Maher Arar case, the Syrian Canadian, that have been thrown out because the plaintiffs have been found not to have a cause of action under the Constitution. And the argument that the Obama administration has made is that there are special factors, that's the phrase that appears in these cases, special factors counseling against giving a cause of action to people who are abused in this context. And this context means is sometimes a reference to national security, sometimes a reference to the fact that they were abused abroad. But whatever the reference is, the idea is these people don't have the right to sue at all. And then the other thing they've relied on is the Military Commissions Act of 2006, which essentially strips the courts of jurisdiction, or attempts to strip the courts of jurisdiction, to hear claims brought by prisoners who have been deemed to be enemy combatants. And the idea is, if you were deemed to be an enemy combatant, you can't come into a U.S. court and complain about the way you were treated. These are all arguments that the Obama administration is relying on to get torture survivors kicked out of court, and unfortunately relying on successfully. We represent the father of, this is an aside, we represent the father of Anwar al-Awlaki, who is a notorious self-styled preacher who lives in Yemen, is in hiding because the CIA has put him on its kill list. And our lawsuit, which is going to be heard before a district court in DC on Monday, asserts that the government's power to use lethal force against an American citizen who is located far from any recognized war zone is strictly limited. It's limited to circumstances in which the person is thought to present an imminent threat to life or physical safety. And the Obama administration is not defending its right to use lethal force against an American civilian in these circumstances. It's not engaging our arguments on the merits at all. Instead, it has invoked the state secrets privilege, saying that this is a case that can't be litigated at all. And the consequence in this context of accepting that argument would be to give not just this president, but any future president, the authority to kill any American citizen anywhere in the world on the grounds that that person has been designated an enemy of the state, and not then be accountable to the public or the court, either before the fact or after the killing takes place. It's really a remarkable statement, and something that I think if the Bush administration had been made, many, many people would be very upset about. But this administration, which earned some credibility on human rights by some of the decisions it made in the first 18 months, I think is getting something close to a free pass on it. So that's all to say that the Obama administration, in my view, started off well, but is not doing well on this issue at all right now, and in fact has again become a real obstacle to accountability. I just want to say, if I had time, why I think that accountability is so important here. You know, there's an autobiography. President Bush has just published his autobiography. I haven't had the chance to read it yet. But I did read a couple news reports about it, and apparently there's a passage in which he discusses the waterboarding of KSM, and he says that he personally approved it. Actually, he says more than that. What he says is the CIA came to him and said, will you approve, or somebody came to him and said, will you approve the waterboarding of KSM? And he said, damn right I will. And I think that the problem with the situation we find ourselves in now is that if nothing is done about what took place over the last 8 years, then torture will remain on the table as a politically feasible option for the next administration and the one after that, even if you trust this administration not to exercise it. And I think that many, many people do. This is not a rule that will be limited to this administration. It will be available to the next one too. Now, that's not the only reason I think that accountability is important. Senator Clinton was talking about Cambodia the other day, and she made a very eloquent and compelling plea for accountability for human rights abuses in Cambodia. And she said, you cannot move forward, I'm paraphrasing now, but you cannot move forward without looking back. And that is essentially what President Obama said when he went to Indonesia about 6 months ago. Again, on YouTube if you want to see it. You cannot move forward without looking back, without dealing with history. And I think that the failure to hold the architects of the torture program accountable is something that makes American leadership on human rights issues much, much weaker than it could be otherwise. So that's another reason why I think it's important. I think I'll leave it at that. Thanks.